Hi, you are being sent this video because you are about to have your deposition taken, and we thought it'd be helpful to give you some do's and don'ts to think about before you actually go have your deposition. This list is not intended to be fully comprehensive. You will probably have a call with your attorney to talk about some things beyond what we're going to discuss here, but we thought it'd be important to share some do's and don'ts. I'm Jonathan Negretti, the founding attorney at Negretti & Associates.
And I am Ray McKean, the firm manager with Negretti & Associates.
For the purpose of this video, Ray is going to play the attorney and I'm going to play the deponent, which would be you in your deposition. We're going to go through 5 do's and then 5 don'ts, and hopefully this will be helpful in getting you prepared and putting you at ease before your deposition. Let's start with the first do. Do be honest. You always want to be honest in your deposition, no matter how you think the answer is going to make you look. So Ray's going to ask me a question, just a hypothetical question, and I'm going to give you an answer that could potentially seem like it might hurt my case.
Mr. Negretti, have you ever had a headache before the crash?
I mean, I have had headaches before, but nothing like the headaches I have now. So I'm going to break character for a minute. That would be an example of kind of being a little cagey with your answer. We're going to do that again, and I'm going to give you a more straightforward response in a way that might be better when you're asked a question similar to that. So Ray, can you ask that question again?
Mr. Negretti, have you ever had a headache before the crash?
I have. I've had headaches before the crash. I can't say they're the same. These seem a little bit more intense, but I don't want to be dishonest. I have had headaches before this crash. So that's a better way to answer the question. I'm looking directly at the camera in the event that this is a Zoom depo. I'm not being cagey. I'm not shifting my eyes around, and I'm not trying to dance around the question. I'm answering it outright. That's do number 1, be honest. Do number 2, always be brief with your answers. So Ray's going to ask a question, and then I'm going to answer the way that you could possibly get yourself into trouble, and then we'll go back and I'll answer it the way that we think it would be a bit more brief. So, Ray?
Mr. Negretti, do you know what time it is?
I do. It's a little after 10 a.m. And the reason I know it's a little after 10 a.m. is that's when I get hungry. It's in between breakfast and lunch, and I usually get really hungry at 10 a.m. And so I know that it's 10 a.m. right now. Okay, I'm breaking character again. That's way more than what Ray asked. She asked a simple yes/no question, and I answered with a long-winded response. That is the opposite of being brief. So we're going to do that again. Ray, we asked that same question?
Mr. Negretti, do you know what time it is?
Yes, I do. That's it. Ray asked if I knew what time it was, and if I know the answer, I can say yes. If I don't, I can say no. And then I wait for the next question. I don't offer more information than what is being asked at that time. Do number 3, do be respectful. Always be respectful, even in situations where you feel you're being attacked or that you feel like somehow the person asking you the questions is being disrespectful to you. It is your job to maintain respect at all times. So we're going to role play that right now.
Mr. Negretti, would you like to break for lunch?
Yes, ma'am. I'm actually very hungry, and I think that would be great. Perfect answer to a question. What you don't want to do is be disrespectful, ask questions in response to questions. Like if Ray had asked me if I wanted to break for lunch, and I would have said, well, do you want to break for lunch? That's not respectful. That's also not the way that you want to be perceived. Remember, a key tenet to having your deposition taken is you're being judged by the opposing attorney, potentially the insurance company, and any other decision maker that might be in play to assess how you perform in that situation, because it has the same effect, your deposition does, as if you were testifying at trial. In fact, your deposition could be played at trial in front of a jury. And so you want to maintain that level of respect at all times. Do number 4, do be quiet. This is an uncomfortable one because sometimes the attorney might ask a question or might be done asking a question, and then there may be this awkward silence while the attorney looks at her notes, and then decides to ask her next question. Don't offer information in that situation. Just be quiet. It's going to feel awkward. It's going to feel uncomfortable because it's not the way we normally have a conversation with each other. But we're going to role play that. Array is just going to be looking down at her notes, and it's just going to go for a few minutes, and it's just going to be quiet. So that's perfect. She's looking at her notes, gathering her thoughts, and then getting ready to ask a question. What I don't want to do is I don't want to fill that space with idle chit chat. This is not the time to have that happen. So that's exactly what you want to do, is just be quiet and just look at the camera and just wait for the question. The last do, be patient. Depositions can take up to 4 hours sometimes, and that is a long time for people. You're allowed breaks. You'll have opportunities to take a break to get something to eat, or to have a drink, or to use the bathroom, or to even talk to your attorney. But what you don't want to do is get impatient and hope that the next question is the last question, because it may not be, and that may wear on you. So we're going to role play that situation right now about being patient.
Mr. Negretti, wasn't it true that you were texting while driving?
Gosh, how many more questions do you have? I don't text and drive. So no, I don't think that's true. But I mean, we've been here for 3 hours. Is this going to take much longer? All right. Breaking character. That is not the way you want to answer that question. You want to answer the question that's asked, and you want to be patient. And if you need a break, the rule is you can have as many breaks as you need as long as you answer the question that the attorney asked. So if I were to answer the question that Array asked, then I can ask for a break. So we're going to do that again. Array, can you ask that same question again?
Mr. Negretti, wasn't it true that you were texting while driving?
No, that's not true. I actually don't ever text and drive because I don't have my phone next to me while I'm driving. Miss Attorney, do you mind if we take a break? It's been 3 hours and I just need to stretch my legs. Is that okay? That would be an example of how to respectfully answer the question and then ask for the break. And that's totally fine. All right. Those are the 5 do's. Pretty easy, pretty basic rules to follow throughout your deposition. Now we're going to get into the 5 don'ts. And the 5 don'ts are probably as important and sometimes maybe more important than the do's. Don't ever talk over each other. So we're going to role play this. This is unlike a traditional conversation where you can anticipate when someone's done answering their question and then offer your response. You have to wait until the attorney is done asking her question before you interrupt or before you respond. You don't ever want to interrupt. So let me back up. You don't want to interrupt. You want to wait for the attorney to fully respond. So Ray's going to ask a question. I'm going to interrupt her as an example of a don't, something you do not want to do in your deposition. Ray, when you're ready.
Mr. Negretti, isn't it true that you're very familiar with the route that you were taking?
You know what? I think that what you're trying to actually get at is where I was at the time of the crash. And it's not really important where I was. What's important is what the other driver did. And that's what's important for us to be talking about here. Again, breaking character. I have no idea what Array was asking. All I was thinking about was what I wanted to say, which was my frustration that we're at the deposition and then interrupting her with my own response to something she didn't even ask. That's not what you want to do. One, it's disrespectful. So we're breaking one of the tenets of the things you should do. And then 2, it doesn't give Array the answer to her question. So all she's going to do is ask it again. And I'm going to have to answer it again. And we're going to prolong the deposition. It's going to take longer than it should. So don't talk over each other. The other major reason you can't talk over each other is there's a court reporter present during the deposition. And that court reporter, although they can type extremely fast, that court reporter is taking down everything that is being discussed during the deposition. Every question that Array is asking, every response that I'm giving. And they can only type so fast. And if I'm interrupting, they can't possibly take down both of the things that we're saying at the same time. So it makes it really difficult for the court reporter. And then it makes it really difficult later in your case if that transcript is trying to be used in some way because the question wasn't fully asked. I interrupted, gave a response that wasn't even close to what Array was asking. And so now you've got this jumbled mess, and that doesn't work. So that's don't number one, don't talk over each other. Number two, don't eat or chew gum during your deposition. So I'm going to give you an example.
Mr. Negretti, in your own words, can you tell me how the crash happened?
Gosh, I think it was February 15th. And I was on my way to the gym. I like to work out. I work out a lot. And I can't remember exactly how it happened. Okay, I'm breaking character. You do not want to chew gum during your deposition. It is totally distracting. It's distracting while I'm talking to you right now. So before your deposition, make sure, as gross as that is, you take your gum out of your mouth. If I notice during deposition that one of my clients is chewing gum, I will ask them off camera, or if we're in person, I'll have them step out of the room and I'll ask them to dispose of their gum. You don't want to chew gum during your deposition. The same for eating. As funny as this is going to sound, we had a client who was eating a sandwich during a deposition before. Not the time to do that. If you need a break because you're hungry, we can take a break. We'll pause the deposition. You can have your sandwich and then we can come back. But you don't want to eat during your deposition. So don't chew gum and don't eat during your deposition. Number three, don't ever guess. There's a difference between an estimate and a guess. An estimate is something that you knew at one time and you can reasonably try to give an answer to. A guess is something you have no idea or never knew and are trying to just make up at the time of your deposition. It's not helpful. It can only backfire. It is perfectly okay to say you don't know something. This is not the time to sound like the smartest person in the room. So Array's going to ask a question and I'm going to guess. And then we're going to do it again. And I'm going to show you the proper way to respond. Array, when you're ready.
Mr. Negretti, can you tell us how many times you went to the doctor?
Gosh, I probably went to the doctor like 1,000 times. Okay. Breaking character. You don't want to say that. One, unless you really went to the doctor 1,000 times, it sounds like you're exaggerating, which sounds like you're being dishonest. And that was one of the tenets of the do's. The first one actually is be honest at all times. So don't guess. Okay, so we're going to do that again. And I'm going to answer the same question that Array just asked with an honest answer.
Mr. Negretti, can you tell us how many times you went to the doctor?
Gosh, I feel like it was a lot, but I don't want to make up an answer. So I'm not going to guess. So I don't know how many times. Perfect. You can say it felt like a lot. You can say that it was a lot. You can say that you don't necessarily know. You'll have attorneys try to pin you down on this and they'll start saying, was it more than 20, more than 30, more than 40? Simply say, you know what, it's in my medical records. Every date of service was in my medical records, but I can't tell you how many times I went to the doctor. Totally fine. Not a problem. It's better than guessing and saying you've been to the doctor 1,000 times. Number 4, don't dress like you're going to a pool party. Okay. This is a deposition. Everything that you're saying is being taken down. You are most likely going to be recorded if your deposition is happening on Zoom. And you could even be recorded if you were to go into a conference room at the opposing attorney's office. Even if that doesn't happen, you still want to present yourself in a professional way. So no t-shirts, no hats, no crop tops or spaghetti straps. What are other things, Array, that women could wear that would be inappropriate?
I mean, anything with major cleavage, I wouldn't, or anything that's sheer where you might be able to see your bra through it, anything like that, I wouldn't wear.
That's exactly right. Array is exactly right. Just be mindful that everything that you do is going to be judged by the opposing party. You want to put your best foot forward. So you've seen throughout this video, I've been wearing a polo shirt. Totally fine. Would I prefer a shirt and tie? Sure. But could you get away with a polo shirt? Absolutely. You noticed if you look at Array's blouse and if you look at my polo shirt, basic, no writing, no logo showing. That's the kind of attire you want to wear at your deposition. So don't dress poorly for your deposition. take notes or rely on notes during your deposition. So I have a bunch of papers here, okay? If I'm looking at my papers during the deposition, a Ray can ask to see those papers, and I have to produce those papers and share those with her. And if I wrote personal things down or things that were helpful, that is going to backfire on me, especially if you did a prep call with your attorney and you took down some of the things that we talked about, or you watched this video and then you wrote these things down and you have them on a piece of paper. You don't want to do that. Okay. So we're going to do a little role play. So Ray, ask me any question and I'll rely on my notes to answer.
Mr. Negretti, can you tell us what time of day it was when the accident happened?
Let me see. I'm looking for the police report. I've got that right here. It says the accident happened at 4 p.m. So I'm going to break character. At that point, a Ray is going to stop the deposition and she's going to say, Mr. Negretti, what are you looking at? And I'm going to say, well, I have the police report, I have my medical records. And she's going to say, well, I want you to produce all of that stuff to your attorney so I can look at it, including any notes that you've written. But also, I need you to testify to things that you remember here during the deposition and not rely on documents to answer questions. So if you don't remember the time of the crash, it is okay to say, I don't remember. Everyone can go back and look at the police report later and refresh your memory as to when the officer notated that the crash happened. But what you don't want to do is use papers and rely on those papers during your deposition, because a Ray can ask for those, the opposing attorney can ask for those, and those then have to be produced. And if you wrote notes, things that you wanted to keep private or between you and your attorney, that privilege or that confidentiality is out the door. So don't rely on records, don't look at things, don't print things out. What I prefer you do is have nothing in front of you except for your computer if you are testifying via Zoom. And if you're at the deposition, nothing on the table, and you simply answer the questions that are asked with what you can remember. You don't guess. And if you don't know, it's perfectly fine and acceptable to say you don't know. Bonus point. If you are lucky enough to have your deposition be taken by Zoom, consider that a gift. It is not something that you are absolutely entitled to have in your case. The court can require that you show up and be deposed in person. So if you are going to have your deposition taken by Zoom, the reason I say it's a gift is because you need to treat it as if you are sitting in the other attorney's office, in their conference room, potentially even a courtroom, and you want to dress professionally like we've talked about in this video. You want to be respectful like we've talked about in this video. You don't want to eat like we've talked about in this video, but you also want to be in a quiet space. You've heard Ray ask questions, no distractions, no one behind her. You've heard me respond to questions, no distractions, no one behind me, no one else in the room. We have good internet connections. It's possible that the internet can break up. It may have even happened during this video. That's okay. People are aware of that, but it's not guaranteed that your deposition will be taken by Zoom. And so if you're fortunate enough to have that ability, take it seriously, find a quiet space, find a comfortable environment, dress appropriately, regardless of the fact that you are on camera, not sitting in person, and make sure that you're taking your time answering your questions and that you're being respectful and being honest every step of the way. So we hope this video was helpful in getting you ready for your deposition. This video, again, is not meant to be fully comprehensive. We can't possibly cover everything in a short do's and don'ts video, but we are hopeful that by giving you some tips, we've eased your mind. We've given you a little bit of direction as it relates to things you should be doing and things you shouldn't be doing during your deposition. Again, I'm Jonathan Negretti, founding attorney. That's Ray McKean, firm manager. We hope this has been helpful. If you have any questions, don't hesitate to ask. Thanks, guys.